Please start, sir.
A very good morning to all. I cordially invite you all for one-day workshop on intellectual property rights and IPR management for startup conducted in IARE. Hence, I would like to thank our management, Principal Sir and Dr. M. Paul Prasad Sir, Dean Technology Innovation and Incubation Center, for giving wonderful opportunity to organize this workshop. Now, I would like to invite our speaker, Mr. M.V. Aitenak, Assistant Professor in the Department of Mechanical Engineering, IARE. Now I request Mr. M.V. Aitenak, please take over the session, and over to you, sir.
Okay, very good morning to you all. And this is a disclaimer. Okay, this presentation is for educational purposes only and does not constitute legal advices. It is recommended that you seek legal counsel for specific matters. All the copyrights and trademarks of images belong to their respective IP owners and are used for fair use and education purposes only. So, in today's session, we are going to deal about the workshop on intellectual property rights and intellectual property management for startups. So the perspective which I have chosen is about the aspiring young entrepreneurs perspective. That is, they are trying to aspire to become an entrepreneur. Okay, so, and in this particular viewpoint, I would like to proceed with the topics of the day. Firstly, we'll be dealing with IP as a source of innovation. And next about what is the patent filing process. Okay, what are the different types of filing processes which are existing. And then we are going to have a brief introduction about how the searches are being made and how to read a patent. And next we will be dealing about how to integrate the intellectual property rights in the business plan and the strategies of identifying, protecting, developing, managing, and auditing the intellectual property assets. And then we are going to see about the future prospects of the strategic, how to maintain your IP portfolio in the near future. So, okay. So whenever you are talking about the intellectual property rights into the account, the intellectual property rights deals with the creation of the mind, such as inventions, literary and artistic work, designs, etc., which are used in commerce. This is according to the definition given by WIPO. Okay, and whenever you're talking about the definition by WTO, the World Trade Organization, intellectual property rights are the rights given to persons over the creation of their mind, give the creator an exclusive right over the use of his or her own creation for a certain period of time. In the brief, it is a limited period of time. Okay, the main objective of introducing the intellectual property related concepts is to stimulate the innovation and creativity, encourage investments and leading to tech transfers, and to ensure fair competition, protect the interest of the consumer. And whenever you're trying to see, there should be a certain long-term interest in promoting the creativity and the short-term interest, social interest in maximizing the access interest of the generators and the IP users. In short and brief, it is about the win-win scenario. Okay, whenever you are trying to create any type of a product, you'll be trying to monetize that particular product and try to see that it is beneficial to the other people. So whenever you're talking about the intellectual property rights, you'll be dealing with different types of intellectual property rights. Since this the major things what we are going to deal is with about the copyright, trademark, trade secrets, and patents, and mostly about industrial design. So whenever you're talking about an expression, protecting an expression of an author, of a particular person, for example, books or a conference paper, you'll be talking about protecting an expression of a particular person. Then you will be talking about copyrights. When you are trying to protect the brand name or the company's logo, then you will be trying to protect it using the Trademarks Protection Act. And whenever you're trying to seek a protection of a certain secret recipe or a secret information which has got a commerce value with it, then you will be trying to use the trade secrets into the account. And whenever you're trying to protect the functionality of your product, you will be trying to talk about patents. Whenever you're trying to protect the aesthetics of the particular product, you'll be trying to go for industrial design. And whenever you're trying to protect the interest of a particular association, for example, take an example of Hyderabad Halim. So Hyderabad Halim is being protected by the associations, a group of associations coming to protect their rights to say that the Halim belongs to Hyderabad. Okay, the geographical indications are considered to be another example of the intellectual property rights. And nextly, there's another intellectual property type which talks about the plant variety protection. These rights protect the interests of the agriculturalists who will be trying to protect the different types of plants and their plant varieties. And lastly, it's about the traditional knowledge. Okay, so whenever you're talking about the primitive knowledges such as Ayurveda or Siddha medicines, those medicines are being protected using the traditional knowledge registry. So whenever you're talking mainly about the startup companies in the case of the engineering firm, you'll be talking about chiefly about the patent, and then you'll be talking about copyright, trademark, and trade secrets. So let us discuss in detail about how the trademark functionality works and copyright functionality works and trade secrets. So whenever you're talking about the patent, it will be clearly saying you that it is a legal right, okay, which will be granted by the government of a nation to an inventor that gives him an exclusive right to the inventor for a period of 20 years in exchange for disclosing the details of new technologies to the society for its ultimate benefit. Okay, so whenever you're talking about patents, it tries to protect the functionality of a particular product. But whenever you're trying to, while protecting the patents, there are different types of the patents which cannot be protected. For example, you cannot protect the business patents in India. You cannot protect the computer programs. Computer programs does not come under the Patents Act. Okay, it comes under copyright. Okay, until and unless it is a cyber physical system, you cannot protect it using the Patents Act. It should have a software and a hardware embedment. Then only you can protect in the case of the Patenting Act. And whenever you're talking about the trademarks coming into the account, the intellectual property granted by a government to an individual, business, or a legal entity that creates and uses a distinct word, name, or a symbol, or a device to distinguish between the products or services from those to any other entities in the market. So whenever you're talking about the trademark, you cannot really try to, there are different types of limitations in the trademarks. You cannot really say, for example, you are trying to keep a fruit cutting machine. you cannot really trademark the food cutting. It should not be descriptive. It should be distinctive. If it is descriptive, then the trademark may not be granted. Okay. So it uses a distinctive word, name, symbol, or device to distinguish its product or services from those of any other entity in the market. Okay. Trade secrets. The classic example of trade secrets is Coca-Cola. The Coca-Cola can be patented. The recipe of the Coca-Cola can be patented when it was being formulated, but the traders have chosen to protect the formula using trade secrets. And that is the reason the largest span of trade secret protection done till date is one of the product is Coca-Cola. Okay, it is an energy drink which is being used for not getting sleep. Okay, so let us try to distinguish between one-on-one with different types of the IP. Chiefly in the case of the startup perspective, as far as engineering is concerned, apart from trademark, you'll be trying to use trade secret, or predominantly you'll be trying to take care about the patents, industrial designs, and copyrights into the account. So whenever you're talking about the patents, it protects the technical enhancement which is novel, unique, and useful. In the case of industrial design, it is going to protect the aesthetic appearance of an article of use. And in the case of the copyright, it protects the expression. Even the duration of the protection varies with one IP to the other IP too. For example, in the case of patents, it is 20 years itself and no extension can be given. In the case of industrial design, your right has been protected for 10 years and then it can be renewed once more for 5 years and then later transformed to copyright. In the case of copyright into the account, you'll be getting the protection of your rights about 60 years from the death, after the death of the author. Okay. And in few countries, they will be writing it as 50 to 60 years. Okay. You'll be getting 50 to 60 years plus protection coming to the account. So whenever you are trying to talk about patents or different types of IPs, you have to pay certain type of annual fees or renewal fees to maintain the rights. Okay, in the case of patents, you have to maintain it annually. In the case of industrial design, you have to maintain it after the 10 years and then you can renew it for 5 years. And in the case of copyright, there is no fees is required to maintain it, as the registration is not mandatory. So when is the registration mandatory? Whenever you are trying to talk about the registration coming into the picture, in the case of the copyright, until and unless you think that the protection is that necessary and mandatory, any work what you create from the date of the creation is considered to be your own copyright itself. If you register it, it's good and fine. If suppose a litigation comes to you, X-faculty has tried to infringe the work of the Y faculty, then the matter comes about the copyright infringement case. So in the case of dealing of such events, it's mandatory for you to go for first registration protection and then file a case against them, done in a proper process. And whenever you're trying to talk about when are you going to apply, few people, there are different types of IP strategies which they will be doing while filing a particular patent or filing a particular IP. In the case of the patent, you have to file it before the launching of a product into the market. In the case of industrial design too, you must try to file it before the launching of into the particular market. But in the case of copyrights, you can do it at any time. It's because of the Bernice Convention. Okay. So it all depends upon your strategy, what you are going to use while filing different types of IPs into the account. So where shall we file these types of IPs? So whenever you're talking about the IPs into the consideration, you are having a separate patent offices in each and every country. Please make a note that the right what you get is not internationally protected. It's only nationally protected. So whenever you're trying to talk about the national protection, you'll be trying to go for the regional patent offices which are available in your own country. And why do they exist? Is to promote the mutual benefit for the both inventors and for our own country. In return for the full disclosure, Indian Patent Office is going to grant you certain rights to an inventor for a period of 20 years. And the patent is published and disseminated to the public so that the others may study your invention and improve upon it. All the things which the focus will be there is about improving the daily lifestyle of the common people and trying to drive the economy into a positive way. So whenever you are talking about the patent offices into the existence, they work according to the acts which have been set up by the Indian government, according in lines with WIPO and WTO. Okay, these are the different types of acts which govern the IP laws. For example, in the case of patents, we'll be talking about Patents Act 1970. In the case of talking about the trademark, it will be as per the Trademark Act 1999. In the case of the protection of the Copyright Act, it will be as per the Copyright Act 1957. And similarly is the case of industrial design, geographical protection, etc. While trying to protect your patents, especially in the case of the biotechnology, you must try to take the no objection certificate from Biodiversity Act, such as NBA, etc. Okay, you must try to take a no objection certificate and then you must go for patent. And Mumbai, the head office of industrial design is located at Kolkata. The trademark registries are available at Mumbai, Delhi, Kolkata, Chennai, Ahmedabad, and the geographical indication registry is located at Chennai. So whenever you're talking about dealing with the intellectual property rights and investing on the intellectual property rights, your money, I just recommend you to say that investments are subjected to market risk because the fight defending it and trying to maintain it and trying to sustain in the market costs you high. Until and unless you think that there is a commercial value in your patenting, you may try to plan it accordingly. And when you should file patent and how to defend the patent depends upon his or her own business plan. Okay, and whenever you're talking about the patent processing, firstly, you will be preliminarily, now you have an idea and you're thinking that your idea is novel. Okay, fine. Go for provisional patent filing. That gives you the date of priority of the first come, first served basis. And then you'll be given a time of 12 months to file a complete specification of your invention after doing different types of market searches and find the investors, etc. And then try to build a prototype. You'll be given 12 months of time. If the 12 months of time is not really sufficient for you, you'll be given an extension of 6 months of time, okay, as per the satisfaction of the reasons what you give for the contract. But there is a thing that if you are going to extend after 6 months, after the 12 months period of provisional patent filing, your priority date also changes. For example, I have filed in the month of January 2020 and I failed to file in the month of January 2021 the entire specification. I'll be going for an request to extend my time for filing the different type of patent. Same patent in 6 months I'll be getting the result. Okay, I'll be filing it. Then the controller says you that you are going to get your exclusive right will be protected, but your priority rate changes 6 months. That is, it will be changing to July 1st because 6 months should go away. Okay, and your protection starts from July. Okay, so it's always necessary to see that you try to protect your rights at the right time, at the right place. It's all about the IP strategy which any company follows. Okay, and whenever you are talking about the protection of your rights, you must keep your idea secret until you file your patent, or you could lose patent rights. Generally, what happens is that in the case of the patenting processes, especially losing the novelty, whenever the patent search happens in the government registry, it generally the patent loses with 3 different reasons. One is because of lack of proper novelty in the patent. Nextly is because of lack of proper claim strength. Okay, we'll discuss it in detail. Lack of proper claim strength. Another thing is that lack of proper disclosure of the information to the public using in the form of a patent specification. Generally this happens. So whenever you are talking about the patent strategy, you must be very clear about when you must try to publish, when you must try to file, when you must try to publish, and when you must try to go for request for examination. Okay, in general process, any patent what you file will be published. Even though you file the steam engine innovation, now it will be surely published as in the patent journal that you have done an invention in steam engine now. But the thing is that you won't be getting a patent. Okay, so the maximum of the consumers will be taking into the consideration about the patent publication as the ultimate process of completing the patenting. Okay, patent has been published, just like journal for getting published. They'll be thinking that patent published, okay, everything is fine and good. But that's not the process. So after the patent publication, you must try to pay a special fee for request for examination, and that fees can be paid after between 48 months from the date of filing. Few people, and then they will make sure to file a request for examination or not. Okay, and there are other types of special things, such as you can go for international searching authority, get the patent examination report, and then go for the patent grant. There is a shortcut way also available, but the general process is that you get a request for examination, then the first examination report will be issued to you, and then you must file a response for the first examination report, and then you will be seeing that whether the patent grants or not depends upon the satisfaction of the information what you give to the controller. If the controller is not satisfied with the information provided to you, then he'll be asking you to come for hearing. And then if the information provided to you is satisfied by the controller, then he will be trying to give you a patent grant. And the patent grant will be notified in the Gazette, and the certificate will be available to you in a digital format. After the grant of the particular patent, you have to maintain the patent annually by paying an annual fee. So in between, there will be different types of oppositions coming into the account. There will be, because you may accidentally, incidentally, or coincidentally, you may have tried to infringe the rights of the other person. So the infringement happens pre-grant or the post-grant. Okay. So you must be very careful while really trying to file a patent to say that you does not infringe the rights. Recap. I have filed a steam engine patent. I have gone for first examination report, and then I have filed a response to. But there is another guy who knows that the steam engine already exists and it is already there in the public. So he'll be filing a opposition for you, stating that before the grant, stating that the steam engine already exists and the person what he have filed is nullified, or the invention does not work. So the burden of proof lies on the inventor. Okay, so that he had to prove that his invention works, and the burden of proof also lies on the particular person who is going to file a case against the innovator. Okay, he also had to show a valid evidence that the patent is not functional or the patent have infringed my rights, etc., etc., etc. After the grant of the patent, there will be post-grant opposition. Okay, so where even though your patent has got granted, they will be giving 1 year of time for really registering post-grant opposition. If anyone who is having same type of business interest or same subject knowledge, okay, same state of art, they are working in the same state of art, they have to really, if they try to identify any type of clauses, then only they can try to go for filing the post-grant opposition. In other words, pre-grant opposition can be filed by anyone, but the post-grant opposition should be filed by the person who is working in the same state of art. Okay, so in any case, if you are clearly going all through the process, as I've already discussed to you, it is clear that the filing a patent is cheap and defending it every time is considered to be a costly affair. Okay, so before planning for IP protection, please be careful about your detailed business plan. Okay, so whenever you are talking about a patent into the consideration, firstly you must remember is about the filing date and the grant date. Abstract, what is the patent written about? Its description, what are the different types of independent claims, what are the different types of dependent claims, what is the pre-write of this particular document, and what are the different types of the cases, the history of cases does this patent have. These are the different types of documents or different types of information which you are going to see in the case of the patent infringement. So let's try to see a basic patent document. So can anyone say a product, please? Please type any product to make a patent search. Any product of your own interest? For example, you are trying to patent a phone. Okay, there are different types of searches which you can make. Okay, so this contains an abstract, and then it contains a detailed information into the account. Who is the inventor? What is the application number? What is the publication date? What is the filing date? And what are the different types of the citations? What it has having? Okay, and who is the assignee of that particular patent? And what class does this patent belong to? And what are the different types of international classes does this patent primarily belong to? And then you'll be clearly saying there are different types of references given over here. These are considered to be the references, okay, which are totally connected with this particular patent. Okay, and then we are going to clearly try to correlate whether our patents are going to be granted or not. Okay, these are the different types of the platforms which are available. googlepatents.com. Otherwise, you can go for Indian Patent Search or freepatentonline.com. Okay, these are the different types of the free patent platform market, and you can try to file patents after making a thorough search and clearly identifying yourself or satisfied yourself as a true and the first person to innovate a particular patent. While filing a patent, preliminarily, you must always take care about having a detailed business plan, a plan for the operation and growth for the business. Just as a building has an architect plan, the engineering has an engineering plan, you must also have a business plan so that you try to manage your business, deal with the operations, and then keeping into the account of the growth of a particular business. The business plan, whenever you're taking into the consideration, you must always try to keep in account of the intellectual property rights. Similarly, in each and every stage of your business management. So whenever you are talking about the setting up a business plan, the role of IP lies towards the management operations and the growth. Whenever you are talking about the IP protection or identifying an IP or registering an IP or securing an IP, it all talks about the management operations. Whenever you are trying to exploit the IP, when you exploit the IP itself, you will be getting the growth. Until and unless you monetize your patent or monetize your IP, you cannot earn profits from the registered IP. So whenever you are trying to really identify IP created by the startup companies needs to be identified. Unless it is identified as IP, it cannot be secured, registered, protected, or exploited. First thing about filing a patent by the startup is identifying to which platform does the IP belong to. And then you will be trying to clearly identify them as a monetary aspect, and then try to deal it in different types of business strategies. Whenever you're trying to identify an IP, you must always try to keep into the account of the long-term strategy. Okay, if you fail to identify an IP, it's perhaps the largest leakage of any startup company. Okay, but it is also necessary for you to train the individual employees in regards of the IP, and you must always try to retain the employees who filed IPs. For example, if whenever you're trying to talk about the business plan, you must always try to see that the staff of the startup company need to be aware that they use or create IPs belong to the company itself. They need to recognize that the IP is in use or has not created. And they have to clearly keep into the account about the strategies. So whenever you're trying to deal or introduce an IP or IP related environment in the businesses, firstly, you will be dealing with two different cases. Firstly, educating the existing staff, and then trying to create an induction program to the new staff while they are going to join in your new firm. Okay, whenever you are talking about IP, you must always try to see that the people who create IPs have to be given a certain type of motivation, such as a recognition among the peers, or a salary bonus, or a prize, such as a holiday for a foreign trip, etc. Okay, so there should be certain incentive mechanism which tries to raise the morale of the staff, and they try to apply their intellectual knowledge for the benefit of the company. And whenever you're talking about the business plan, you must continuously conduct the staff awareness program and educate the staff about the latest happenings in the case of the IP. It does not mean that you have to educate them in regards to the IP acts and everything. At least you must educate them about what is going on in the case of the IP field, about the product, what you are trying to produce in the market. For example, you're trying to produce a mobile phone. You must be well aware about what are the IPs filed by your competitors in the same research area, and then try to make an advancement to it. And last but not the least, rewards recognitions of the staff who create IP, and you must always try to reward and recognize the staff who will be trying to create a valuable IP for the employers. And whenever you're trying to secure the IP, you must always try to see that whenever you're trying to secure the IP, you must always see that how best you can try to exploit the product potential in the market with respect to that of the laws which are there in the different jurisdictions. Okay, and then you must always try to see that you will be trying to, while trying to go for different types of contracts, while trying to go for different types of the marketing strategies such as franchising,
Please tell, sir.
So whenever you're trying to make a negotiation coming into the account, you must always try to safeguard your own IP using different types of forms such as confidential form, non-disclosure form, etc. into the consideration. For example, of the contractors owning their own IP, you must always try to see that whenever a startup engages a software engineer to write a program, you must have a different type of agreement or a different type of procedure of dealing with these types of culture. Okay, you must also have a IP policy of your own while dealing with different types of the stakeholders of your company. And nextly, whenever you're talking about in the case of the IP is owned by a contractor, for example, you're doing a different types of contractual job, even though the startup company paid for the creation, the IP still will be owned by the contractor. It is necessary to have an assignment deed of the IP for the contractor to be to the startup. Okay, whenever you're talking about doing any engagement in regards to the IP, it's better to have a mutual deed, assignment deeds or license deeds or a turnkey agreement, and then you can go have a specific clarity whom the IP belongs to. For example, you are doing you're interested of doing a business of what do you call it as Zomato, like app, and you don't have an app creator. That's the reason you have contracted your assignment. Okay, this is my idea, and I want the app to be developed as per what your competitors are having. So then the particular company whom you are giving a contract will be trying to develop a particular product, but you must be very clear about what is the ownership of the work, whom the ownership of the work will belong to. And this should be clearly done using different types of agreement procedures, and legal agreements should be done. Okay, the business plan should require the contractor assign IP to the company that engages them. Identify the most likely contractors that are engaged that may create an IP. Okay, whenever you're trying to go for a contractual agreement, it is not necessary for you to go for a normal contract things too. For example, hiring a chair for your own office. You need not go for IP related contract. But whenever you're talking about the technological aspects, you must go for it. And then you must always try to read the document carefully while signing any type of these types of agreements, and then proceed ahead with the business. Whenever you are talking about the registration of the copyright, you must be very selective about protecting the rights. You must be very selective about what type of right you must clearly try to protect. Okay, whether you want to go for a copyright protection, whether you trademark protection or a trade secret protection, etc. For example, you have innovated a fantastic recipe, okay, which is going to solve the problem of agingness. So the recipe may be protected using patents. The recipe may be protected using the copyright, and the recipe may be protected using the trade secrets. So it's all depending upon the selectiveness of the particular startup company of what type of protection which they would like to go ahead. In the case of trade secrets, there is no monetary aspect which have to be dealt with, and there is no registration of the trade secrets is required to. Okay, so the most what do you call it as the most powerful approach of protecting an IP is considered to be trade secret. Until and unless the information is disclosed to the public, it is considered to be your own trade secret, and this should be done using different types of agreements and related clauses into the account while taking an employee, or while going for a franchise, or while signing a contract, etc. Okay, and whenever you are talking about the patents, okay, there will be always a dilemma between whether should I go for a patenting or should I go for a trade secret. For example, in some cases, the innovations may not be patentable. For example, I want to create a fantastic recipe for the creation of the aging. They may not be patented, okay, or may be patented. So, best decision is about seeing the long-term perspective of the business value of that particular patent, and then try to invest the amount accordingly. For example, if an innovation may be patentable, but a decision may be made that it is best left unpatented. For example, you'll be seeing n number of patents which are coming from different types of people who they get the patent, but you'll be seeing there won't be any commercial value. Okay, do you think that this idea of patenting that particular subject was being left by any other primitive market people? It's certainly not. It's only because unless and until you have a market value, you won't invest in really going for a patenting process, because it is considered to be the most expensive process of protecting your own rights. You have to pay the fees annually. You must pay it annually not in one country, but in different types of countries. So whenever you're talking about an invention may be best patented, but some part of it may be best left outside patent specification and left to remain as trade secret. Sometimes in the case of the pharmaceutical market, what they do that they'll be writing in the form of ranges. Sodium from valuable information rise upon a particular proportion of the medicinal chemicals to be kept into the consideration while making a particular pharmaceutical product. So even though the patent expires, there is each and every chances of maintaining the trade secret and your license agreement signed and depending upon the trade secret related activity. So generally this type of strategy, the third type of strategy will be followed in the case of pharmacy. Okay, so it all depends upon the choice what you make, and then the work what you want to protect, and the strategy which you are liking to use in long-term way. Okay, whenever you are trying to make a decision of registering an IP, you are going to get it. Okay, that okay, you will be getting an exclusive right, okay, to exclude others from the IP in strategic relationship. But you must also try to understand that if the IP is not registered, what are the risks involved in it? If the others learn this particular about your product, they may try to exploit it without talking about different types of, without your consent too. Okay, so whenever you are trying to plan a perfect business plan, you must identify the process, the criteria first, deciding when the registration of IP should be done, when not to, appreciating in each case the consequence of your decision. Okay, you have to clearly make a decision and then try to face it accordingly. Okay, whenever you are talking about the registration of the patent, you must always try to say that in which process you would like to go ahead in the case of the registration process, whether I want to protect my innovation nationally or internationally. If it is internationally, in which phase I have to go for. For example, there are two phases in which you can go for international protection. One is using the PCT route and another one is using the Paris Convention. So in the case of Paris Convention, you must pay each and every country different types of visas, okay, in a selective way. And in the case of PCT, you can go in a single go, okay. So it depends upon the different types of convictions, what you would like to go, the strategies what you are going to follow, and then at each phase of your decision, you must always try to remember that whether you have to proceed ahead or not. Okay, and then comes who will be the decision maker, what are the criteria which you are going to take into the consideration while making a decision, and what types of information are needed to be collected, research for the decision to be made, and what is the best information basis. Okay, and here is the thing. Whenever you are talking about the example, okay, your company has got a large R&D staff and dedicated IP related aspects. So each phase of the written innovation is need to be prepared in such a way that what is the technology you are going to deal with, what is the state of the development it is having, what are the different types of competing technologies which it is having into the account, okay, what are the opportunities available, and what is the economics which your patent is going to produce to the company, okay, and then try to make a decision accordingly. For example, whenever in the real time comes into the picture, your IP manager may say you to go for filing approximately about 20 provisional specifications, out of which your IP manager will be trying to decide, the IP committee may decide to proceed ahead only for 4 to 8 applications to the next stage. It's only because until and unless you get a monetary benefit, there is no point of you investing on the patent. Okay, and then trying to talk that, okay, I have got this many patents. Another question which comes into the picture is that whether you have got the patents really been commercialized or not. Okay, and after taking a certain decision by the IP committee, the CEO of the committee decides to approve only 1 or 2 or 3 patents to proceed towards international filing. Okay, this is how the streamline happens in each and every IP firm or in each and every institution. Okay, and then they will go ahead as per the decisions of the company. So whenever you're talking about a detailed specification business plan, it will be consisting of all the policies upon which the protocol lies. And it clearly explains what is the function of each and every committee, and then explain the tools which you're going to use for written evaluations, for an analysis, what are different types of reports you're going to take into the consideration, and then search for the reports and what are the different types of literature surveys which are available, and then only you'll be trying to go for a business plan formation. Okay, the business plan should be confidential and restrained upon the staff. The confidentiality should be maintained by every person in the startup company, and the disclosure should be carefully monitored. Okay, whenever you're talking about the protection of the IP in your startup firm, the confidentiality clause plays a very vital role in protecting the interest of a company. Okay, you must always see what type of the confidentiality agreement you are going to sign and what are the conditions of the disclosure which you are going to give in the particular agreement, and when would the startup company be prepared to be the recipient of another person's confidentiality information. And then you must always have a careful protocol of maintaining each and every document and carefully auditing each and every disclosure in a systematic manner. So whenever you're talking about the confidentiality agreement, one of the agreements which you are going to sign is about the staff employment agreement. The key staff that moves to another employer and take the knowledge with them represents the largest leakage of IP for an enterprise. In a new employer, a staff member uses the knowledge gained from the startup represents the loss of competitive advantages. The competitor may become better equipped. The loss of competitive advantage results in economic disadvantage. See, whenever you are trying to employ a staff, you'll be clearly seeing that either you get a new staff or your most trusted staff may leave the company and he tries to apply the knowledge elsewhere. Then you'll lose your competitive advantage. And then you'll be trying to get economic disaster soon and when the particular person leaves the company. Or in case you're trying to recruit the new employee from your competitor company, you must be very careful in regards of the IP strings and then try to proceed with the particular employee accordingly. The survey really clearly says you that the maximum amount of the IP loss happens with the person in trusted relationship, the loss of person in trusted relationship, and due to the competitive intelligence of your company and due to the other related concerns such as the foreign company may have really got a better IP value related protections and then execution done by them, enforcement done by them in the form of patents, etc. So whenever you are talking about the competitive advantages into the account, until and unless you try to maintain a proper staff employment agreement, there is a greater impact of having a loss of competitive advantage with your rival company, and then you'll be clearly seeing there will be market share losses, etc., coming into the account. So you must be very selective in regards of creating a better staff employment registration agreement while recruiting a particular person. So what should the business plan require an employment agreement to say? It says that the staff should maintain the confidentiality. The staff will not use the IP directly employee of the other company or indirectly director of another company. If he have got to know the information that okay, the Y company is trying to implement other different types of strategies. Firstly, you have to be very careful whether there is an IP string involved or not. Okay, and then only you can talk about different types of the executions or the staff management. And next, the staff restrained from the competing with the previous employee. Okay, there is every chances that the staff which you have recruited from the competent company will be trying to so whenever you're trying to recruit, you must be very careful of the IP strings of your company, and then you must try to be very careful while doing the staff management. And nextly, whenever you're trying to exploit the IPs, you must be very attentive of two things, such as by using your own innovation or by licensing it to the other person. Okay, by using your own innovation, the chances of getting the IP theft is very low. But whenever you're trying to go for granting a license to the others using the technology transfer, you must be very careful about the clauses which you are going to give to the other company. For example, you are also required to give a sub-licensing clause. Okay, whether you are going to entertain the sub-licensing of the product what you have, then what is the royalty you are going to get? For example, you have tried to manufacture an automobile. Okay, and you are going to give a sub-licensing to another manufacturer who is going to produce you a carburetor. Okay, so in one invention, you must try to clearly see that whether the company which you are trying to license your product is going to use and sells the thing to the market and give you the royalty, or they will be trying to sub-license your IP to other people for manufacturing the same product. Okay, so you must be very careful about the sub-licensing clause. Okay, and nextly, whenever you are talking about the exploitation of the IP, you must always try to see that it is in a win-win strategy. Okay, and whenever you are talking about the exploitations of the IP, then there are two situations coming into the account. The IP protection happens in a national wide or in a country basis. So whenever you are trying to go for the other territories, then the licensing clauses will be depending upon the laws of the particular country. Okay, and then you must always be careful in regards of retaining your right to exploit it in your own country, the license of another person who is not a competitor to exploit it in another country. Okay, you must be very careful while trying to execute the patent licensing agreement or the IP licensing agreement, and then you must try to see that it always will be in win-win scenario. Okay, other types of the exploitation applications such as retain rights to use your own application, and nextly the license others in other non-competing applications. For example, whenever you're trying to sell a mobile phone, you may license the same thing to another mobile phone manufacturer, same technology, but you will be clearly having a non-competing clause. Okay, so that your rights will be retained by you and there won't be any conflict of interest which will be arising afterwards. And whenever you are talking about the retaining of the rights, okay, retain rights to use your own application and license others in other non-competing applications. For example, in the case of the plastic formulation, okay, you have done a plastic formulation. Pipes you are given for a plumbing industry. Spectacles you have given for a optical industry, and rainwater tanks you have given it to a rotary molding industry. The car parts and trims you have given it for a motor vehicle industry, and the boating trims you have given for a boating industry. Altogether, the patented product is one and the same. You have just tried to protect your rights in the case of the plastics formulation. But the applications of your license agreement depends upon the product which they are going to manufacture. And that is the reason you must always be very careful while protecting your own rights in your own terms and also respecting the other's business motive and proceed with a win-win scenario. So whenever you're trying to make a business plan of your own startup company, you must always try to remember that the business plan is a blueprint of for IP to be recognized, identified, secured, registered, protected, and exploited. A business plan with that addresses these IPs will be likely to outperform one. Okay. So until and unless you will be having a careful business plan, just like what I discussed in the case of the plastics formulation, greater monetary benefit, then only try to invest in the IP related thing. Otherwise, I say you that you can have an alternative source of business development, okay, and then proceed ahead. And next, please, how to make your IP driven returns for your business. How to strategically. Firstly, the business strategy must drive the IP. Intellectual property right should not be viewed as a legal issue separate from the business. Instead, intellectual property strategy and business should be integrated so that the IP reinforces the business. The intellectual property right should be a window into the business future, such as you can talk about the patent applications which will be giving a technological roadmap or upgrading your own brands using the trademark. Okay, and know your technology and business while working with IP concepts. While trying to talk about protecting your own rights, even if you don't understand the competitive landscape, you should know how your product works, how you plan to make money. Okay, your attorneys needs to know your risk and tolerance abilities to provide you an effective concept. Okay, you should know what you are trying to invest and in which product you are trying to invest and what is the risk-taking leverage what you have, and depending upon the circumstances, your legal attorneys can clearly say you in which way you can proceed with. Okay, and the ultimate question what comes into your mind is that what drives the economic value for your business? Okay, is the economic value derived from brand name? It is the economic value derived from the source code or with the product design or with the technological future or with contracts and relationships? The answer is that it depends upon all, and it depends upon the strategy which you are going to use it. Okay, and types of the agreements which you are going to do it. It all depends upon the proper business plan. Okay, and whenever you are trying to determine how IP will be supporting your business, you must always try to see that how do you protect your business drivers. Not all the agreements or not all the technologies are patentable in the case of the business activity. Okay, you must always have a strategic approach whenever the time changes. Okay, so whenever you're trying to use the IP strategies, you must always take into the account what is patentable and what is not patentable. What is copyrightable and what is not copyrightable. Okay, and then try to make the decisions accordingly. And always sound IP strategy today always allows you to have your business updated in the future. Okay, and a question to you all is that do not fall love in your IP. Even if you understand, if you don't understand the competitive landscape, you should know how your product works and how to plan to make money. Okay, once again I repeat it, because until and unless you are clearly confident that you're going to invest on IP, you're going to get a monetary benefit. And in the future, it's recommendable for you to have a necessary legal counsel and then proceed ahead for filing a patent in your respective subject field and to have a better business advantage over your competitors and to have a better profit. Okay, so it's all about the selective approach of using different types of IP and then trying to make a profitable business. Okay, overall, the great companies start because the founders want to change the world, not to make a fast buck. Okay, if you are not really going to, in the case of startups, if you are not going to build your own dreams, then someone else will hire you to help them build theirs. So it's for you to decide of how you are going to go ahead while applying different types of IP strategies and then thinking about the monetary aspects and in a long-term perspective. Okay, this is about the today's session about the workshop on IP and intellectual property management. Thank you for attending. Any queries? Okay, sir, I'll be surely sharing you the slides. Okay, the sources what I have taken is from this particular thing. Okay, and this presentation is a compilation work of these different types of sources.